very much, everybody, for coming along today to our webinar. So perfect. As I said, today is employee dismissal and the pitfalls to avoid, the cost of getting it wrong, and more importantly, how to do it right. We'll also look at some of the cases where Irish employers fell foul to the legislation, and cases where employers successfully dismiss an employee. And if you don't mind, as Rachel said, we'll take your questions at the end. Now, I know that this probably isn't the most exciting topic, and definitely not as exciting as maybe where you're going on holidays for 2016, but we've tried to make it as interesting as we can and to break it up where possible to make it as useful for you. So we really hope you do find it useful today. Employee dismissal is one of those troublesome issues that is a constant issue for small employers. And I think testament to that is the fact that 40% of all cases heard in the EAT in 2014 were unfair dismissal cases, and that was the majority by a long shot. So again, the aim of today is that you leave here with a basic understanding of the procedures and the rights of employees and employers when it comes to terminating employment, and with a few tools in which to do that. So I put up a figure there on the screen. You might see it, €4,960,000. And what is this ridiculous figure, you're probably asking yourself. In fact, this figure of almost 5 million is the total amount that the EAT awarded out in compensation for unfair dismissal cases in 2014. To break it down, the average individual compensation awarded to the tribunal was approximately just under 18,000. And I think that you'll agree that these are pretty much significant figures, and I would certainly question as to how any small business could stomach or swallow a fine of nearly €20,000. Now, of course, compensation isn't the only possible sanction issued by tribunals. They can also offer reinstatement to an individual where they return to their old position with no break of service. Essentially, you'd have to pay their salary for any time that they were out, or re-engagement where they return to their old position or a similar position, but there would be a break in service. So reinstatement and engagement and compensation are all on offer if you find yourself in a tribunal. However, what I would say is that in 2014 there was only one case of re-engagement and one case of reinstatement. So really, compensation is the normal solution and the most common one. So you just so you would be aware that you are going that the compensation probably is going to apply to you if you were to be on the losing side of it. But the message today is that you don't have to become part of that statistic, and you don't need to put yourself at risk to these fines. It is possible to dismiss an employee and to avoid the large fines, and we'll talk you through how to do that now in just a little while. Firstly, though, I do want to give you just some of the legal background around dismissals and unfair dismissals, just to kind of set the scene for you, if you like. Firstly, Irish legislation allows for 3 types of dismissal, and so these are recognised in Irish law. Firstly, it's unfair dismissal. Unfair dismissal is governed by the Unfair Dismissals Act, and as we've already said, the majority of cases in the EAT are unfair dismissal cases, so that's really where we're going to focus today, is those unfair dismissal cases. There's also a term you may or may not be familiar with, it's wrongful dismissal, and this arises at a common law level. An employee can bring a claim of wrongful dismissal where the dismissal breaches the employee's terms and conditions of employment. For instance, if an employee wasn't given their valid proper notice period or paid for holiday pay on termination, something like that. Claims for this are usually brought to the Circuit or High Court, and normal criteria that we'll talk about later wouldn't apply here. There's also constructive dismissal. A claim for constructive dismissal arises where the employee terminates their contract, but does so because they really felt that they were left with no other alternative based on the actions of the employer. So I just wanted to give you this information so that you were aware of the different types of dismissals. There's no really need to get too bogged down in it at this stage, but just suffice to say that we're looking at the unfair dismissal side of things here today. So moving on then to look at the unfair dismissals, I want to just go through with you who does the unfair dismissals apply to. Firstly, Unfair Dismissals Act applies to employees with 12 months service. So once they hit 52 weeks service in your company, they're going to have that unfair dismissals legislation applies to them. They also must be over the age of 16. And finally, an interesting one, they will also have not reached the normal retirement age for their employment. So if there is no retirement age provided for in your contract of employment, then technically an employee could continue to work on indefinitely, and any dismissal after what one might assume is the normal retirement age may give rise to a claim for unfair dismissal. So in this regard, what I would say to you, slightly off what we're talking about, but definitely you really need to have a contract with a retirement age if you're going to assume that you want to be able to retire people when they hit that 65 or whatever the age may be. It is a little bit of a topical issue, I should say. And we've seen changes in the UK, but it's definitely something around retirement that we're following up and kind of keeping abreast of. But absolutely, if you wanted to put a retirement age in a contract of 65, then that's what your stance would be in your company once you are consistent in how you apply that. So just going on from then there, if you do have an employee which falls into these categories, and really for the majority, most people will be in these, it'll be a high percentage of your employees will tick all those boxes, and you're looking to dismiss them, then you really have to have some extra caution is definitely required. So just again, briefly, who does the legislation not apply to? Persons working for a close relative in a private house or farm, provided they both also live in the same house or farm. So again, we would quite regularly have customers who would have family members working in their business, but would question whether employment legislation applies to them. Generally, it does. The only exception is if it is in a private premises, a private house or farm, and they both live there. Members of the Defence Forces, Gardaí, civil servants, I think from looking at our delegate list today, I don't think that's going to apply to too many people. Also, it only applies to employees. So if you've any subcontractors or contractors working with you on particular projects, the legislation is not going to apply to them. And an interesting one as well is individuals on your fixed term or specific purpose contracts, so your short-term contracts. The legislation will not apply to them where the written contract does exclude the legislation. So really with this regard, what I would say to you is that it's extremely important if you have short-term workers with you working on fixed-term contracts. It's really important to have contracts in place for them, particularly if you wanted to look to terminate them early or even not renew their contract when it expires. So that's just a point of there, but these people are not covered by the unfair dismissals legislation. I want to take you through what happens if you did get a claim, and really the reason why I want to take you through this is because it's a brand new process, and major changes happened in around the whole area of employment legislation and governing bodies last year in Ireland, and it's the first time such a change happened in many years, over 60 years I suppose. So as of 1st of October 2015, there is a whole new structure around how claims can be raised and how they are dealt with. It's very much a positive change, as the new structure simplifies and streamlines and really just quickens the whole process. Previously, it could have taken up to 2 years and more for claims to be heard. We're now seeing that turn around much more quickly in a matter of weeks. So really, there's really a positive thing, I suppose. So today, rather than having different bodies such as NERA, the Labour Relations Commission, the Rights Commissioner, the EAT, we now just have one body, and we have two in the Labour Court, but the WRC, the Workplace Relations Commissioner, they're looking after all employment matters. So this is going to be a term that you're going to hear a lot more now of, the Workplace Relations Commissioner. And just to go through some of the differences and what's similar, as before, an employee will have 6 months from the date of dismissal in which to submit their claim, and 12 months in exceptional cases. That has not changed. But a few other points that have changed, and again, just to bring these to your attention, I suppose, just so you know. In terms of an employee is bringing an unfair dismissals claim against a former employer, they will submit a complaint form to the Workplace Relations Commission, and you'll be notified of that. So that's the letter you'll get in the door from the Workplace Relations Commission. A new part of the process is that initially a case may be referred to a mediation officer, and this is again brand new, and this would be where the Commission feels that the complaint can be resolved through mediation. I suppose the thing to note there with mediation is that it has to be agreed upon to enter into mediation. Both parties have to agree upon that. And if they don't, and if it is not felt that mediation is necessary, it will go straight to an adjudicating officer for a hearing. And the key difference again with the adjudicating officer, that in the past this would have been would have been 3 representatives, but now we would just have 1 commissioner would hear a hearing. And also another big change here is that hearings will now be held in private as opposed to publicly in the past. And then your appeals, if somebody was to appeal a commissioner's decision, they would raise their appeal in the Labour Court. So I think just to note that that is a new process. It came in 2015, October 2015. It's a new change for Ireland legislation. But one thing that hasn't changed, and it's important to note, that where an unfair dismissal claim is brought against you, it is presumed that the dismissal was unfair, leaving the employer with the burden of proving that it was actually fair. Now, don't stress about it. It's not to say that all odds are stacked up in favour of the employee. That's definitely not the case, and it's definitely not been the case in our experience either. And we do have some cases to prove that for you. But it's just to know that it's the burden of proof lies with the employer. So I hope I've set the scene there a little bit, but it definitely leads us on to the question now as to how do you dismiss an employee correctly to protect yourself should you get that letter in the door from the WRC. I want to touch firstly on your new starters because we spoke earlier that the unfair dismissal applies to those employees with 12 months service. So it's really therefore crucial that you manage any new employee that you have started with you, and you want to manage them correctly to determine whether or not they are the right person for your organisation. Do they fit with your organisation? Are they what they say they were in an interview, etc., etc. But if you decide that no, they're not the right person, dismissing somebody with less than 12 months service is going to be a lot easier, and you have a lot more options than you would after 12 months. So to be honest, we could probably have a whole webinar itself just on managing a new starters and what you need to do. But just some of the key points, I suppose, for you, is firstly, issue them with a contract of employment and a staff handbook. These are really key because these documents will clearly set out the terms of their employment, ensure that the staff know what's expected of them. So from putting something as simple as your break times into your more complex policies, I really can't underestimate the importance of this. And of course, it's legislation that you need to give them contracts as well. You need to put a good induction in place as well. Train them, show them what the policies are, who different people are in the organisation. Again, this is all about letting them know what is expected of them. You want to put also a probation period in place, and this will be set out in your contract of employment. But the probation period will give you a period of time in which to evaluate the employee's performance. And you want to have regular review meetings during that probationary period, giving feedback, letting people know how they're getting on. If they need to make improvements, you better make sure that you've told them that they need to make improvements. But one thing that I would say, and we see it time and time again here when people come into us, don't let it get too late. If you've got an issue, deal with it straight away. Don't get to 11 months and go, oh, I think I want to get rid of this person now. You need to be dealing with it throughout that first probation period. And also remember that if you do decide to dismiss somebody, you have to take in their notice period. So it could be that they have 11 months and 2 weeks service, but their notice period would bring them over the 12 months. So you just need to bear that in mind. Sorry, I have a bit of frog in my throat, but it's absolutely typical now, so you just have to bear with me for a moment. Okay. So we're getting into the nitty-gritty bit of it now, I suppose, and it's not always as simple as dismissing somebody who's a new employee. And of course, issues in the employment relationship, they can occur at any time, regardless of how long an employee has been with you. And again, we see that all the time. So when looking to dismiss an employee with longer service, there are 2 key points that you need to keep in mind. And I'm going to talk around these 2 points now. This is what I'm really going to focus on. But the first point is that you really need to have substantial grounds for the dismissal, and that the second point is that in doing so, you have to apply fair procedures to the process. These 2 points are absolutely critical, and it's what any tribunal judge is going to look for if you end up in front of a judge. So I can't really overemphasize the importance of these 2 points. If you get these 2 points ticked off, you will have a fair dismissal. So if you are considering dismissing an employee, taking a few precautionary steps, ensuring that you can tick off these 2 points and that you have a fair procedure in place, then you're looking a lot more better to protect yourself in that WRC case. So if we look at the first point that we mentioned, the grounds for dismissal, Irish legislation specifically states what these grounds are. So we start off with capability, competence and qualifications of the employee for the work that they were hired to do. When I talk about capability relates to the physical and mental ability of the employee. So it's probably the most common one around capability that I deal with is people on sick leave. And it's really, really a common issue. And it is possible to dismiss somebody who is on long-term sick leave. Now, I will say there's a process to be followed around that. You have to tick your boxes, but it is possible. Competency, this relates to the performance of an employee and their ability, their skills, their knowledge. Does their output match their expectations? Are they making mistakes? If somebody is not performing well enough, if they're not meeting the grade, let's say, again, that's an acceptable reason to dismiss them. And qualifications, maybe the qualifications that they say they weren't sufficient for the job. That's again another reason for dismissal. Conduct, it is fair to dismiss an employee where there has been a series of behavioural issues or where there are whether they be serious of minor issues, continuing issues, and then that amount to gross misconduct. For example, sexual harassment would be a gross misconduct, I should say. But continued poor timekeeping, that's a conduct issue that could also relate to, that could eventually end up in a dismissal if you have somebody who's continuously coming in late, taking long lunches. If you go through a fair process, that too could lead to a dismissal. Redundancy is also classed as a fair reason for dismissal, provided it is a genuine redundancy and that your basis for selection is fair. Redundancy, that the process will be slightly different than maybe the process for capability and conduct that we'll really kind of drill down into today. So your redundancy process will be a little bit different. But again, we'll focus on the first few points there today. Also, another fair reason for redundancy would be the fact that the continuation of employment would contravene another statutory requirement. I think the obvious one there is if you had somebody who was driving for work, the purpose of their role was driving, and that they had been banned from driving for whatever reason. So that would be a reason for dismissal as well. And then finally, any other substantial grounds. And this is a bit of a catch-all phrase, really, to be honest with you. Well, what does that mean, I suppose, is the question. We're very much dependent on case law for this. And there have been different cases, but I suppose the most common case that we'll be looking at here is a breakdown of trust and confidence. But in truth, it's probably not used all that often. Although, in general from these 5 points, what I take is that there really are quite a few reasons why you can dismiss somebody, and really they are quite broad. So in truth, there are many possible reasons why you could justifiably dismiss somebody. So we really are ticking off that first point that we spoke about earlier.
And even probably just to give you a couple of examples in some of the employment appeals tribunals, like for example, those employee versus Rangeland Foods Limited, where DAT had upheld an earlier rights commissioner's decision and reiterated that the dismissal based on lack of competency was not unfair, as the employee had been sent on refresher training courses, was well aware of his poor performance and even failed thereafter to improve. So again, it was completely upheld that there was no grounds of unfair dismissal. And you have on the likes of what you touched on there, Laura, the conduct. Again, an employee versus Rostera Irish Meats Group Limited, where it was found that the actual employee who was he was employed as a boner in the meat plant had refused to wear protective gloves. And again, this was dismissed by the Employment Appeals Tribunal recently, as it was quite clearly shown that there was a properly conducted risk assessment which had led to the introduction of this new safety measure, and that it was a refusal and the continuous refusal of the employee to wear the protective clothing, which finally led over, in fairness to the employee or the employer, where the employee had received verbal warnings, written warnings, a final written warning, and a 2-day suspension without pay. So really, ultimately they left the employer with no option but to dismiss him. And he was also afforded an appeal, which was upheld. Again, the dismissal was upheld. So it just shows these are different areas. And then when you kind of talked about substantial reasons, there was a claim also there recently, or I should say not too long ago, concerning FC Shepherd and Co., where it was an apprentice plumber. He was sentenced to prison for a minimum of 3 months to a max of 24 months. So again, you can understand that, from the point of view that the contract compliant become frustrated, and again, the unfair dismissal was upheld as well. So it just gives you a little bit of ideas in case law, how these things, when you look at these different types of grounds for dismissal, how they happen as such.
Yeah, thanks for that, Michelle. I think it's really important to have a look at some of the cases, because it's all well and good giving a list of reasons, but when we actually see them applied then is really helpful as well. Before moving on to actually ticking our second box in the process, I want to just look quickly at automatically unfair reasons for dismissal. A lot of people are familiar with these reasons. Dismissing anybody for one of these reasons is automatically unfair. Employees involved in these categories do not have to have those 52 weeks, 12 months continuous service that we talked about. So really, if you dismiss somebody who falls into any of these categories, consider yourself that you're going to find yourself up in front of the WRC, and you're going to find it incredibly difficult to defend the case of this matter. So you're talking about the membership of the trade unions, religious or political opinions, race, colour or sexual orientation, members of the travelling community, age, maternity-related dismissals, any dismissal related to an individual taking paternity leave, adoptive leave, carers leave, anybody exercising their right under the Minimum Wage Act, even asking for requesting pay slips, anything like that. Unfair, we've touched on redundancy, but unfair selection for redundancy. I've worked on a lot of redundancy cases, and with a lot of people going, well, we're making redundancy, and we have one lady where she's got children, and she works part-time anyway, so she doesn't really need the job because her husband has a good job. They're not fair reasons for selection for redundancy, so you don't want to even be going down that road. Employee legal proceedings against any employee who might have any legal proceedings against the employer, and a protected disclosure. When I say protected disclosure, that would be the whistleblowing. We had a new whistleblowing act came into legislation in 2014. So if anybody who is really blowing the whistle against their employer, they can't be dismissed for that, and that would be automatically unfair as well. And actually on the whistleblowing, if somebody is blowing the whistle and you dismiss them, we spoke earlier that the maximum penalty for a dismissal, for an unfair dismissal in terms of compensation, is 2 years' salary. For somebody, if you dismiss somebody because they're blowing the whistle and they're making a protected disclosure, it's 5 years' salary. So it's quite an increase, and that just kind of again shows the emphasis that kind of the government have put on this as well, in terms of creating compliant workforces and businesses. But I only wanted to briefly touch on that slide, and I've gone on far too long already. But we'll move on to your procedure now. So when we talk about the procedure, and in terms of ticking that second point, it is paramount that you have a fair procedure if you want to tick that second point. And often employers believe that they have a fair reason for dismissal, and often they do. They very well have to. They've got that fair reason, but they end up losing a case in the tribunal because of the procedure that they followed. And I think Michelle would have loads of cases to show you on that. So in order for an employer to dismiss an employee, even in instances of gross misconduct, so really serious misconduct, if you want to dismiss somebody, you are expected to have a clear and documented procedure in place, and you are expected to have followed that very closely. This procedure is usually included as part of your disciplinary procedure, and it's set out generally in your employee handbook. That's the best place to have it, I suppose. And just in my experience, it's quite an unknown fact amongst employers out there. It is actually a legal obligation on employers to supply your employees with a procedure of dismissing an employee, so a disciplinary procedure, within 28 days of them starting employment. And so you could argue that if you don't have that in place, you'll be breaching you'll be in breach of some laws. And again, the importance that the government has placed on that, because you've got 2 months to give a new employee a contract of employment, where we're saying you've 28 days to give them a dismissal procedure. So really, I can't stress enough how important it is to have a written disciplinary procedure in place, and for everyone to be familiar with these procedures. It's one thing to have it there, it's in a drawer, it's saved on whatever drive, but are your managers, are your employees, are they aware of that? Do they know the bones of it? If you don't have a written procedure in place and you dismiss somebody, you will lose a tribunal case that is brought against you. It really, really is simple as that. And we had a Bright Contracts user actually kind of came to me before Christmas, I think it was given the story behind why they ended up using contracts and bright contracts, because they actually had found themselves in front of a tribunal and they had brought in assistants to help them defend the case. But when they got up in front of the judge, he said, where is your disciplinary procedure? Where are your contracts? They didn't have them. The rest of the case wasn't even heard. It was struck out and he had a €20,000 fine. So that's the kind of thing that you're looking at if you don't have your disciplinary procedure to follow. So again, if you take one thing from today's webinar, it really should be this, to have a disciplinary procedure in place. And it's too late to try and roll one out once you have an issue with an employee or once you want to deal with something, because that's not going to look in any way favourable on you either. So you really need to be doing it in advance and doing it now, I suppose. So really your disciplinary procedure will act as your framework to all dismissals, and if you want to dismiss somebody, this really is your first point of reference and it'll be your reference guide throughout that dismissal. Michelle, do you want to come in with a case? Did you have a case?
Yeah, I mean, like exactly what you kind of spoke about there. I mean, this was a case, again, where the complainant was awarded 40,000 in compensation. And you can understand that's very significant for anyone's kind of books. But it was a case where Kelly versus Dundalk FC, where the employee was deemed to be unfairly dismissed from her role as the commercial manager by Dundalk FC. And that literally the tribunal came to the conclusion that failure to implement any fair procedure in dismissing the claimant, and that the respondent had not given the claimant any relevant contract of employment. And obviously that there was an outlining issue where she was dismissed by reason of ending of a personal relationship between herself and one of the directors. So again, you can see how it can get very sticky if there's personal relationships, but then it all ultimately boils down to the fact that there's no written contract, like a written statement in place, and there's no disciplinary procedures. So when they come to make this decision to let somebody go, you need to show what you followed in all instances and the reasons. And there's also, again, another case where Miles Cummins versus Bernard Keane Limited, again, where the EAT had awarded 12,500 for unfair dismissal to a butcher who was suspected of stealing meat and possibly money from the employer. And again, as Laura said earlier on, we do get a lot of calls, and that's always when alarm bells go off at employers when they suspect that there's something untoward going on and they perhaps don't have the proper cash procedures in place. Or systems in place maybe to check it, or even CCTV. And again, you need to be very careful with that. So they kind of come to a presumption. They don't follow fair procedures. They don't even if, you know, if there was an absence of procedures. But even in that case, he was awarded 12,500 because the AT had found that there was a total absence of fair process, and in circumstances where no evidence was added of any fair or reasonable procedure to deal with a disciplinary issue, leading up and including the dismissal of the claimant. So where is the burden of proof? Like how do you show the AT if you go in as an employer the reasons all along as to why you came to the conclusion that this person had to leave, and that there was no other way but to terminate the employment? And you know, there's just so much, like, you know, all the time when you look at it. I mean, there's loads of cases even in front of me here. You could go on all day, and it's a pity, because a lot of the times these people, for whatever reason, you know, need to go, but you just need to do it properly, which again, I know what the webinar is all about. But
I just wanted to pick up on one point that you made there, Michelle, in your first case with the Dundalk FC, and you have a personal relationship, and that's something that we come up against time and time again. We're dealing with small employers, much like yourselves, and you might have had Johnny or Mary working for them for 20 years, and it's great, you know, she lives down the road, it's a perfect relationship, sure, why would I need to have that in place? And in my experience, I've come across this: when you're dealing with people, you just don't know what's going to happen, and you as a business owner have to, in terms of employment legislation, you just have to think this is a business. You can certainly be friendly, I'm not saying you can't, and you're definitely going to continue a positive relationship, but just put a few simple steps in, just protect yourself as much as you would take out liability insurance or insurance on your property. Your procedures and your employee contracts are going to be your insurance for your employment relationships, which is really key for your business as well. But I just wanted to make that point when you mentioned personal relationships. It just sprang to mind.
And I suppose, like, they're never clear cut, even when you kind of look at it. I mean, there was a case there recently, I know that somebody, well, not recently, sorry, it was last year, when it concluded, where an employee, and, you know, on the face of it, when you listen to it, she was like I think it was a night shift warehouse operative, and she was dismissed after 8 bags of skin milk powder went missing on her shift, which, in fairness, was all while she was suffering a blackout due to the amount of alcohol she consumed before starting work. So again, you would naturally just think, okay, surely this employee can't win this case. I mean, there's loss of product, suffered a blackout, I mean, coming to work even intoxicated. I mean, but she was awarded 20,000 for unfair dismissal. And again, it was all down to the basis that there was no notes of disciplinary meetings, and on behalf of the respondent, and at no stage was it ever set out that the process to her in writing, so she could have even kind of come back, with any sort of defence. Now I don't know what defence she did come back to be awarded 20,000, but it must have been pretty good. Yeah. Sorry, Laurie. Yeah, go ahead.
Michelle, I could talk all day about
I
these
know,
cases,
yeah,
but
yeah.
we'll keep going because I'm conscious of time as well. So I want to talk about the first stage, and many of your disciplinary procedures will normally include an informal procedure. Your informal procedure, you're going to implement that in first instances of minor misconduct, spoken about lateness or perhaps maybe unsuitable dress or appearance, and you'll also go to your informal procedure for per performance or first instances of per performance, and that might be really, it depends on your role, whether it's per customer service, mistakes, low sales rates. Again, it really depends on the role, but they often result in an informal action being taken. The informal procedure really can be as simple as a manager sitting down with an employee, highlighting that there is an issue, asking the employee if there's any particular reason for the issue, and then laying down what is expected of them. The informal procedure is really a good way, if you're keeping on top of things and you know what's going on in your organisation and you suspect something is awry, get in there early and deal with it. We had a case in a previous organisation that I worked with where we had an employee who was always coming in late on a Thursday, and we couldn't, for whatever reason, we just couldn't get to the bottom of it. We didn't know why. And it was getting on everybody's nerves, to be honest with you, particularly other employees who were in at 9 o'clock. But the manager sat down with the lady in question, and it turned out that actually on Thursday morning, for whatever reasons, she didn't have childcare arrangements in place, so she ended up being a little bit late by the time she dropped the children to school. And it was an honest reason, and we were able to work around her hours and make some adjustments and deal with it that way. So the key thing is that if you have an informal procedure, they can solve issues that otherwise might just become escalated and bother people to no end. So it really can be a successful tool in nipping something in the bud. And it's that the earlier that you can address an issue, the better. And I really can't emphasise that enough. And don't let them fester, and don't let them get any bigger. The informal procedure for me really is a positive tool, and for employers it's a great way also, apart from nipping something in the bud, it's a great way to show how reasonable you are, and we were able to show we were reasonable in that case by adjusting her time. So you're showing that you're reasonable and that you're supportive, and that's something that judges just love to see as well. If you were to ever get in front of a judge for whatever reason, they want to see that you were reasonable throughout the process. So if you're starting off well here, it's going to look very favourable on you. However, there are some pitfalls with informal procedures that, again, I've come across in the past, and I see them time and time again. Firstly, would be failure to take notes and document employee meetings. Michelle has just touched on taking notes there a few minutes ago. Although you're saying it's informal, absolutely it is informal. It's not part of the formal process. But if you want to in any way depend on these meetings later to progress into a formal process, if you don't have any minutes taken or a note that you met with Mary about this situation, you might not as well have had the meeting. So keep just with a simple record, a simple note, sat with Mary, discussed this, she's going to do X, Y, and Z. It's short, it shouldn't take you too much time, but it'll really help your case if you need it later on. And also, we see this time and time again with small employers, it's failure to progress to the next stage, the formal stage. Yes, I say to employers, be nice, be reasonable, but up to a point where actually, now I need to take this seriously, now I need to progress. And there's often a fear among a lot of employers that, they don't really want to, but you need to progress and you need to move things along, otherwise you're not going to resolve the issue. So don't stick with the informal and nice approach. Always, it's time to progress and it's time to move on. So let's just do that. So moving on to the formal process, which is getting you on the road to dismissal, I suppose. And you'll be starting this process where your per performance is really continuing and it's not improving, and where you have some more serious conduct issues. Unfortunately, the process, the fair procedure and the fair process that we've been talking about, it's not a static one, and it's not one that we can just say it's point 1, 2 and 3 and you're going to be fine. There is no one-size-fits-all procedure that can be adopted by employers. And it really depends on the seriousness of what is at stake, what the issue was, and how they may impact on other issues. So you kind of have to apply, again, it's a reasonable approach. However, that said, there are some core principles that you should be looking to apply. We're going to kind of go through these, and I feel that if you take on board these points, you're going to be a lot safer, I suppose. So investigation. The investigation will be to establish the facts of the case, to establish whether a disciplinary hearing is appropriate, whether you need to actually go forward into the disciplinary. Now, please don't be scared when I say investigation, oh my, what does she want us to do now? But it really is just establishing the facts and preparing the evidence. It doesn't necessarily mean that you're going to have a lengthy or arduous investigation. So if you're considering disciplining somebody for poor performance and repeated poor performance, it may be a case of just getting together their previous appraisal forms, any notes and any informal meetings that you've already had, productivity data, phone level recordings, anything like sales records, that kind of thing. You're just kind of gathering the information. But if the offence is something if the offence is something simple and straightforward, then your investigation will be too. But it's just a matter of going through that process. But if it's something a lot more complex, then yeah, you will need to maybe interview some witnesses. You may want to seek to get some client input or undertake some audits, computer investigations. Really depends on the severity of what you're dealing with. If the matter is particularly complex and requires interviews to be conducted and evidence to be sifted through, then it probably is preferable to get a manager who is not directly involved in the case to conduct the investigation. But I know realistically in small organisations that this is not often possible, and an investigation may need to be conducted by the line manager or the business owner themselves. Just with regards to investigations, if the case is particularly serious, you may want to suspend an employee while the investigation is being conducted. And because we actually had a case, it's sprung to mind, we had a case where somebody was working in the care environment and there were allegations made against that individual. And the company felt at that time that whilst they were trying to find out where those allegations are founded or not, it was most appropriate to suspend that individual for the period. And that was perfectly acceptable. But what I would say is that if you're suspending somebody to do an investigation, they should be suspended on full pay. So I suppose the old adage of innocent until proven guilty would apply there. So the rest of the procedure, just to look at it, will be obviously the investigation that we've talked about. You then invite the individual to a hearing. You'll hold the hearing. This is your disciplinary hearing. You don't make any decisions at that hearing. You're going to end the hearing and then you're going to go away and consider the facts. You then make your decision and you'll issue that decision to the employee, always giving them the opportunity to appeal. That's really, really important. Any decision you make, the employee must always have an opportunity to appeal. And then you move forward with your, whatever that action is, dismissal or a warning and review and monitor that. So I want to drill down. I know I've just kind of gone through that process. That is the process that you go along, but I want to drill down into each one of those steps if you don't mind. I'm just conscious of time, so I'm just going to go as fast as I can, but keeping in all the main points. You have to invite the individual to the hearing, and you must put this in writing. Again, it's all about keeping your paper trail, but you must invite the individual to a hearing in writing. And this letter should give a brief summary as to why the disciplinary is being held. So a brief description of the allegations against them. It should also state that the outcome of the disciplinary process may be the dismissal of the employee. It's very important that you notify somebody, and cases have been lost on that fact that the employee wasn't notified that they actually might be dismissed. And you must warn people. of the outcome. You also must notify the employee that they have a right to be represented by an appropriate person at the disciplinary hearing. Sorry, excuse me. The code of practice on this suggests a trade union member or work colleague. When people ring me on this, I would generally say, yes, trade union and a work colleague. But if somebody comes to you and says, well, I prefer nobody work knows about the situation and I'd like just to bring my brother or my sister, going back to the whole concept of you being a reasonable employer, a judge is going to be very much open to the fact that if you say yes, you can bring your brother or your sister, that's fine. Again, you're just making sure their role within the meeting is kind of very clear. Once the brother or the sister is not a major barrister or legal eagle, you're usually fine on that. I would tend to stay away from the barristers and the lawyers attending your disciplinary hearings. So what happens at the hearing? At the hearing, you will present all the information to the employee, and you want to give them the opportunity to respond fully to the allegations or the complaints against them. The employee should have access to review any piece of evidence that the employer has. So whether that was your old performance appraisal meetings, or interviews that you had with other colleagues in your investigation process, that should all be made available to your employee. Also, it's very advisable to have a witness present, because really you want that third party. If they've brought somebody, great, but have a witness on your behalf as well, and they'll also be there to take minutes of the meeting, which is really important. The hearing should be impartial and fair. The person conducting the hearing should be objective and impartial. There should be no bias or prejudgment. Employers need to remain impartial. Really, I know that can be difficult for an SME, but you really do need to remain impartial. Following the meeting, the manager who had the hearing will decide whether they need to have further investigation, or they'll decide on a penalty. And when they're considering that penalty, they'll have to decide on a penalty that is fair and proportionate to the employee's breach. Now, I'm just talking about that in breach in most, so we're just talking about the crime, I suppose, for want of a better word. We've touched on the point that the sanction issue must be fair and proportionate to the crime. It is the role and responsibility of the individual conducting your hearing to make that decision based on all of the evidence to hand, and your own company's disciplinary procedure. So most disciplinary procedures will have a list of sample incidents of misconduct and gross misconduct, and they'll also have a list of sanctions. So it's up to you then, chairing or holding the hearing, to match and decide where your issue falls and what is the appropriate sanction. So just to give you a little bit of an idea to help you, I've listed the 5 most common sanctions. Again, these were listed in the Code of Conduct. So for a verbal warning, you generally issue a verbal warning for a minor misconduct issue. If you have repeated minor misconduct or a more serious misconduct, then you would be well within your right then to issue the first written warning or a final written warning. Again, we're talking about no one size fits all. It's difficult to say which. You're going to have to weigh up the case. And it's perfectly acceptable if it's such a serious misconduct to skip the verbal warning and the first written warning. If your disciplinary procedure allows that, you can skip stages and issue a higher warning, if you like. So then moving on to the more serious sanctions, action short of dismissal or dismissal. You're going to be issuing them where you have a really continued minor misconduct, such as continued late keeping, or I was going to use Michelle's case of the not wearing the health and safety gloves, and I'm not sure that's a continued minor, but it's a continued serious misconduct or gross misconduct. But 2 key points that I would just want to raise on this quickly is this: dismissal really is going to be your last option for minor misconducts. You really need to have shown that you have moved through a process, and this is again in line with the WRC's Code of Practice on Disciplinary Proceedings. They want to see that good practice requires a number of stages in handling the disciplinary processes. So you'll be moving through each process. And also the second point from this slide is that although dismissal would be the last stage, in instance of gross misconduct, absolutely you can go straight to dismissal, and that's perfectly acceptable if the issue is severe enough. I worked previously on a case where the employee ended up going to the manager's home and threatening his family. So absolutely that was gross misconduct, and they proceeded with a dismissal, which was perfectly understandable. So finally then, very briefly, once the decision has been made, you confirm this in writing to the employee. The employee must be given the right to appeal with a time frame in which they can appeal, which the appeal can be lodged, and details of who the appeal should be lodged to. The time frame would usually just be a week, I would recommend. If you have issued a warning, not as far as dismissal, but a warning, the employee is entitled to a period in which to meet the improvement. and they're also entitled to assistance from you, the employer. And you'll also need to say the time frame for which disciplinary sanction will remain in their file. Usually, depending on the severity of the warning, that could be 6 months to a year. So if you have made the decision to dismiss, then you should put all the details with regard to their last working day, their final salary, payment of holidays. You want to tick all those boxes as well and give the employee information of that. If an appeal is lodged, it should be heard by a different person to the person who heard the disciplinary hearing. And again, I know that can be very difficult for small employers. Particularly if you're looking at a dismissal, I would really advise maybe some external consultancy, or maybe if somebody on your board of directors, try and have it as a different person, because it's going to look a lot more favourable on you. So I want to finish up so I can pass you back over to Michelle, because I know she's got a few more points that she wants to make, and I'm conscious of time as well. But I just want to say, we go back to our 2 tick boxes and ask ourselves, can we tick off that second point in relation to fair procedures? The answer is, in my opinion, absolutely yes. Yes, you do have to be diligent and you do have to keep on top of things. But you can do it, and you can dismiss somebody fairly. Again, the advice is small employers, if you get that far down the line, assistance is there, and it's always best to seek external assistance, particularly if you're in any way unsure. So I'll pass you back over to Michelle now. I think she might have a few more cases for you.
Wow, okay. I suppose even just to start off, I'm just reading a couple of comments. Quite a few of them actually coming through, so they're being busy. But one of them there, from a gentleman who states that his disciplinary or his current disciplinary policy consists of a few lines, a paragraph at most. So he said that he will definitely be reviewing it today or very shortly, and will give you a call, Laura. I'm sure you've scared him somewhat. So I suppose in conclusion, it's very clear from the onset the great importance of giving each of your employees a contract of employment. And so the relationship between the employer and the employee is clearly defined and agreed by both parties from the very start. And I suppose like the contracts of employment accompany policies and procedures, such as obviously the company's grievance and disciplinary procedures, are vital in avoiding a lot of the unnecessary disputes and grievances later on, not to mention the very fact that employers are obliged by law to provide them to their employees. So I think we've really learned it's imperative that we do this as employers. And unfortunately, quite a few employers are of the presumption that having little or no paperwork will somehow disguise the employment relationship in some shape or form. Like I would get that quite a bit on the phone, where it's sort of, well, if I give a contract or I have these procedures, Michelle, like what's going to happen then? Like I can be done on that. I think it's, to this day, it sort of amazes me at the resistance to put things in place, considering employers can literally go from hero to zero overnight if your employee becomes disgruntled. And what I mean by that is, like, we all know Billy, for argument's sake, who's been with you probably nearly 16 years. He's a couple of pints with you in the week, in the local pub at the weekend, and he drives the company Jeep around the clock for free, and everybody loves him. And then, all of a sudden in comes Billy's sister, and she's the lady that took over the management of the office since Margaret left 2 years ago to get her hip replaced and hasn't been seen since. And the very fact that you're still in denial that Margaret hasn't come back to you for whatever reason, you're still refusing to make Billy's sister legitimate, just in case you want to fire her in the morning, and she surely, be to God, has no rights on this. We all know this person, if it's not you, we know a relative or a friend that has hired Billy and has hired Billy's sister, and the contract is there. It exists. Regardless, if you don't put that written statement, if you're in front of an EAT, the contract is there. You've offered them a job, they have accepted, there it is. And the procedures then, they're the first two things when a grievance is brought or an unfair dismissal case is brought up in front of the EAT. That's what they look for. The first thing, where is your contract compliance? Where is the disciplinary procedures? Did the employer follow the disciplinary procedures? So you're really off on a serious back footing, but having nothing in place. And unbelievably, there is quite a few employers out there, and they do exist. And you have to always remember that the very fact that the Unfair Dismissals Act was amended in 93 will tell you how irate the EAT was becoming with employers for failing to comply with the Act and for not following fair procedures when disciplining and dismissing their employees. So the fact that they amended will give you an idea that there's just zero tolerance at this stage. So like the tax man, there is no way of avoiding this. And if you're really it is only a matter of time if you don't put it in place. Like if you own a business and employ staff, you need a company disciplinary procedure, and failure to furnish your employees with a written copy of these procedures that clearly outline how the company will discipline and dismiss an employee during their term of employment with you is just pushing you on the back foot. I mean, again, I know I've already covered that, but I suppose it's tireless now at this stage explaining it. Like the kind of explanations and poor defences that have been given over the years to the EAT during the unfair dismissal cases by the representatives are seen little more than unprofessional and disrespectful. So you just need to be very careful. Like if I was to look, for example, even just briefly into our Bright contracts, like you'll see we've already embedded, if we go into our handbook and we move up the top into our main procedures, we've already included and quite rightly so, the disciplinary procedures. So we go through very quickly with the purpose, the scope, the policy, so it gives a good outline at all stages, even for managers and supervisors, kind of what they'll be using them for and the correct way of doing it. We have a look at misconduct and what's construed as misconduct, gross misconduct, and we also look at our informal counselling. So again, something Laura touched on earlier on, with kind of how we would kind of go, when we would use that, let's say what instance we would use it in. And then we move into the formal disciplinary procedures where we could have an investigation that might run alongside it, and then the actual disciplinary procedure. So again, it's what Laura kind of touched on earlier on, the different stages, when to use them and perhaps when they can be skipped. We include our mechanism again for our appeals, and we also look at the grievance, again, dispute procedures if they come in along the same side with the disciplinary. So it all sits inside in your handbook here, which is very useful. And as Laura said earlier on, like if I went and looked in one of the contracts that we've done up here, let's say I have a lady, Amy Kane, you know, for the Unfair Dismissals Act, like you go into certain sections, let's say where we have our probationary period. And when we go and we look in and we preview the contract when it's ready to go, like it'll again stipulate the different terms and conditions that are, you know, included once an employee is on probationary. And we also look at, again, the retirement age, and we make sure we have it in. And another very important one to have, again, with the Unfair Dismissals Act, which you can include through, let's say, the software here, is your temporary and short-time layoffs. And again, that there's other areas govern that in the contract as well, you know, notice periods and when it can be used, when it can't. So, you know, there's not serious constructive dismissal cases or anything being taken against you. So I know there's quite a bit, then there's a lot of kind of summing up to do. But I suppose essentially when we look at it, what do we need to do? If I am an employer, I need to have a company disciplinary procedure in place. I need to give a written copy to all my employees within 28 days of the start date. And I need, more importantly, to follow my own procedures. I need to be fair. I need to be consistent. I need to look at things objectively when making a decision, so I don't take things personally or overreact. And I need to be clear on why I'm disciplining that employee. I need to be upfront and state clearly the penalties and what will happen should a similar offence or more serious offence occur at a later stage. And I'll do this through the letters that I'll be issuing out to my employees. And that I'll always look at every case individually, like, because they are all unique. So I'll take a detailed look at the facts before I make my decision. I won't jump the gun, and I give the employee an opportunity to defend himself or herself and justify their actions. I won't, hopefully, ever act as a judge and jury in any one case, and I will make the punishment fit the crime. So I will always be realistic when deciding on what stage I'm at. I'll inform the employee of the right to be represented. I'll inform the employee of the internal mechanism for appeal, and I will definitely document everything in writing with copies available for both parties. And I'll give the employee an opportunity to defend themselves and justify their actions. So it's all the same things, again, that Laura has gone over, that we can see all the time with having these procedures in place. I know it does seem on the front very lengthy, but you'll find when you kind of look at a lot of it, it's just fair, you know, it's fairness, it's being reasonable, and it's kind of doing what you should do. And the important thing is take the personal context out of it, where, you know, if Margaret's there and you've always tried your best to get rid of Margaret, and now, you know, she does the one thing ever wrong in her 12 years of service, and straight away you jump the gun and that's great, we'll get Margaret out the door on that. You know, ultimately it's going to lead you to an unfair dismissal case. I'm just very mindful of, the level of questions coming in at the moment.
Yeah,
so we better get started with them.
Started on some of the questions. I'm just looking at some of them while you're talking there. we mightn't get through them all, but there was one I saw somewhere. Is it okay to do contracts and procedures for employees that have been with us for a couple of years? Absolutely. It's never too late. And let's say, for example, you had an inspection from the WRC and they come in. What they'll do is they'll look for all this documentation and that'll be on their checklist. But they'll give you an opportunity to put it in place as well. But I would be saying, yeah, it's absolutely fine to put it in now. No problem. There was another question there. So I'm just reading them as I go, but there was one question there: can I let an employee record a meeting? And this is a really topical one now. Obviously, everybody has different devices in their back pocket now, mobile phones, and it comes. I've had the question as well: if I want to record this meeting, and what do you say back to that? The question, I suppose ideally for a lot of employers, they would prefer not to have the meeting recorded, and it's much more. And you can't say that. I would be initially saying to the individual, well, we would prefer that you didn't record. And we have, let's say, Mary here. She's acting as our individual third party, and she's going to take minutes of the meeting, and they'll all be shared. Actually, I saw that question came in: can you share the minutes of the meeting? And yes, and you should share the minutes. They should be agreed upon. You won't be trying to do anything untoward in a hearing. You're trying to have a reasonable conversation. So do share the meeting. So firstly, yeah, I would be saying we prefer to not have recording of the meeting. And we prefer just to take the minutes. I've been in cases where that hasn't gone down, and the employee is aggravated and they want to record it. Listen, I would say to you, okay, yes, let's record the meeting, because you don't want somebody to record the meeting unknowns to you in their pocket. You want to have it there. If it's going to be recorded, well, I want to know about it. But what I will be saying is, if you do allow a recording, you say to the employee, well, the company is going to hold copyright of that content, because you don't want that recording to be ending up on YouTube or Facebook or whatever it is. So put a copyright agreement in place and have one. Maybe you might need to postpone the meeting, whatever it is. So if it's pushed, yes, let's be open and let's be transparent here. You can record it, but we'll have the copyright of it. Thank you very much. I would say there. Do you see any coming in, Michelle?
There's quite a few of them. I don't know where even to start. I know that there's one there. I know it's more on the contract side of it for today. Do you need? Do you need the contract of employment signed? Honestly, best practice, yes, it would be great, but the legislation would state that the obligation is on the employer to have the contract of employment signed and dated. But again, it would be great to have your employee have it signed. And obviously that they're there and that they've witnessed it and they've accepted the terms and agreed to them. But I say, if for any particular reason that employee did not wish to sign it, I suppose what we would suggest in that instance is to email to them and verbally speak to them as well, to see, is there any particular reason why they're refusing to sign the contract? Is there a term or condition that they feel, is not accurate, or whatever it is that they may be holding back on, and see, can you just discuss this, sort it out and get it signed? If not, just obviously write to your employees, so you will have a written record of it, to let them know that you're aware that they've refused to sign, and that a copy will be kept in-house, and obviously one is gone to their address anyway, and should they ever wish to kind of have a look at it again, there's no problem at all. And if they ever want to come in at a later stage, you have an open door policy, and you can discuss whatever it is at the time. So it's not the end of the world, but we say best practice would be good to get it signed. I have contracts in place, not as detailed as yours, but I have not issued dismissal procedures. Is it too late? No, that is the biggest thing. We'll tell everybody. It's never too late to get your house in order. It never is, because even if, God forbid, there's nothing going on in the in employment now at the moment and in your company, but something could happen 10 weeks down the line. At the very most, it's shown that you're trying to get things right. You're looking at the statutory obligations you have an employer, and you're trying to get your house in order, and that'll always look good and stand to you.
I just saw one there. Is it? I can't find it at the moment, but it was, can you discipline somebody for the same issue twice? Absolutely. So what would happen is, I don't know what the issue you might be thinking of there, but let's say somebody had bad customer service. There was a complaint about a customer, and that led eventually to, let's say you issued a written warning. What happens is that would stay on the employee's file for a period of time, generally 6 months. And if somebody repeats that, or has continued bad performance, or repeat of whatever the incident was within that 6 months, then you'd be holding another hearing, and you'd be saying this is continued bad behaviour, and we're going to increase that warning now to final written warning. So again, you're going up the process. Let's say, for example, there wasn't, within that 6-month period where you say, right, we're giving you the written warning, this warning is going to be on your file for 6 months. And then within that 6-month period, you're obviously reviewing, you're meeting with the employee, you're reviewing their performance very closely. But let's say there isn't a reoccurrence of the issue. So what happens is that warning goes off their file effectively. So then if you have another issue with the employee, you're going back and you'll be starting again. So you're effectively, that disciplinary process is kind of ended, and then you're starting again. So you might end up issuing another written warning. We were on at that stage. So because the other one had expired. Now if over time there was a culmination of lots of different warnings, then they may validate a higher warning. But in general, the answer to your question is yes, you absolutely can.
And we've a question there. If the employer doesn't provide the contract in the first 28 days, and remember your contract is within the first 2 months, your disciplinary procedures within the first 28 days, and leaves it even a few years, can that then be used against the employer by the EAT? Not necessarily. I suppose always remember the contract exists. As I said earlier on, once there's an offer of the job and obviously there's an acceptance from the employee, there is your contract. What you're obliged to do is furnish the employee with a written statement which outlines I think it's particularly 16 main key areas. Now you can make that as big as you want and you can build it into a full contract, but that's what you're obliged to furnish the employee with. So let's say you haven't done it in 3 years, you put it in place then, and then there's a dispute or a case with EAT the year after. No, look, again, the same thing applies. It shows that you were trying to get your house in order, you were trying to make sure that everything was right and legit, and okay, fine, you failed to give it within the correct time limits, but you have done it. So I would never fear. It's better to get it done than just to leave it and face it then, because your fines and the penalties they'll be hit straight away. And believe me, if you go into an EAT, a lot of people say anyone in the legal profession will always throw those in, as we've heard numerous times, as grenades. So even if it's on a completely different level, they'll always say, well, my client here never received contract of employment, disastrous employer, and they never received any copy of their disciplinary procedures or grievance procedures or bullying harassment, like there's no policies in place, this is a shambles. So they will always try to use that against you as an employer. So it's good to have things in place.
There's loads of questions coming in and they're great, and I always find that the Q&A session is really...
A lot of them are quite specific and personal, so we can't really read them out, and I'm sorry, but we couldn't because it might...
Just for what we have here, they're quite lengthy, but what we will do is we will come back to them maybe after today and maybe tomorrow, when we come back to your more detailed ones. But there was one there that I see, if an employee walked out, would there be a comeback? I'm not entirely sure if I understand what you mean there. Are they walking out of employment, or are they walking out of a hearing? If somebody walks out of employment, I never say somebody blows a fuse, flip you in your job, I'm out of here. I would never take that as a resignation.
Be very careful.
Be extremely careful. That's kind of heat in a moment kind of thing. I wouldn't take that as a resignation. If they came back in the next day and said, "Look, I'm sorry, I thought it through. I overreacted," you would be entitled. They would be entitled to their role back. And even if they didn't come back the next day, and you still couldn't take that as a resignation. What I would be doing there would be writing to them and saying, we appreciate it was a heat of the moment thing. Can you confirm this is a resignation? And be asking them to confirm they have resigned. And I'd almost go as far as writing to them twice if you weren't to hear back from them. And also in those letters saying, if you don't reply, we will assume it's a resignation and we'll process the necessary payroll and paperwork, etc., etc. So I'd just be very careful about if I've understood the question correctly. I would be careful about taking that as a resignation. Have we got through enough questions? Have we got through? Do you see any more there?
Yeah, again, there's quite a few, but as you said, they're very kind of tailored towards your own business, and I'd be afraid to read too much of them out, or the level of detail that you're kind of giving into it, because they are really an individual case, and to answer them without knowing the full facts wouldn't be kind of fair on you, or ourselves kind of trying to advise on it.
Just one there, is there a stage of verbal warnings and written warnings? And I'm not entirely sure the question there, but it's kind of highlighted something to me. When we say a verbal warning is the first warning of your formal disciplinary process. Now, although it's verbal, you still give it in writing when you make that decision, and that is really important, that it's a verbal warning, but it's issued in writing. So that is just a point to be made there. And again, that person who asked that question, if you wanted to kind of send it in again and maybe give a bit of a background, we could come back to you directly on that. Just double check if there's any other ones, but I think we'll just, again, conscious of time, and thank you all so much for attending and for all the questions, which are really, really great, and it's great to see that there's an interest, and we've had such an interest in today's seminar, and it's probably something we'll do again, and I hope you found it useful, but I think at this stage we might just call it a day. There are a few questions.
There's quite a lot. I know, and you really feel guilty for going without kind of giving you some sort of I won't say consultation, but just even to give you some sort of, but as Laura said, look, today has kind of been very eventful from that perspective, but we will contact you back and give you even, some sort of an idea of what to do with your current situation, because they're quite specific to your own organisation, so it's best we probably don't go into too much of them. Like, a lot of them seem to be generally the fear of implementing something now after, like you're kind of saying, oh, has a horse bolted? No, it hasn't. If there's no real trouble in there at the moment, and even if there is, it's still better to have those procedures and to have them in place, and most definitely to have a contract in place.
Yeah, I'm looking at, I think we could talk all day, to be honest, because I'm seeing ones I could just keep answering, but
well, when we're gone, we're already 10-12 minutes over time.
Yeah, I think we will come back to you individually if you don't mind. I hope you have found it useful. At the end of the seminar, or when you log out, you will receive a questionnaire just to give a little bit of feedback, and it would be really great if you could fill that in for us, because it just helps us planning our next one and what we're going to talk about next. So again, thank you very much. Hope you found it useful, and hopefully we haven't pressed you too much with the topic, and maybe you'll plan your holidays, and that'll be something else. So,
I know. Thanks very much for tuning in. All right, all the best. Take care now.